Hi, I'm Tricia Dunlap, managing partner of Dunlap Law, a small business law firm in Richmond, Virginia. Here today for video 3 in our corporate governance series. So first of all, if you haven't seen the first 2 videos, you should. Those lay the groundwork for some basic understandings about corporate governance that you need to have in order to fully understand this video. I will give you a quick breakdown on corporate governance. Corporate governance are the laws, rules, and best practices that govern how companies are run. And there can be some pretty significant legal liability if you don't get this right. I personally love corporate governance. I used to be a government teacher in high school in my first career. And now I'm an expert in corporate governance, and I love the ins and outs of corporate governance. It can be very complicated, and there's a lot of nuance. So I thought I would do a video series to help people understand some basics. But this is really basic, so get in touch if you have more questions. So here's video number 3. Today I'm going to talk to you about conflict of interest transactions. Before we get to the substance of today's video, here's a quick announcement about an exciting innovation that we're launching at Dunlap Law. We're launching an exciting innovation called Learning Communities. It's targeted to micro and small business owners who think they can't afford legal counsel. Check out the link below and sign up for updates. Thanks. Now let's get into today's video. Now, first of all, you should make sure you go see video number 2. Because if you haven't seen video number 2 on the role of shareholders, directors, and officers, then this may not make as much sense to you as it should. But let's assume you've seen video 2, and I'll pick up where I left off. Okay, if you are in a small corporation, and let's say there are 5 shareholders, and of those 5 shareholders, all 5 of them are also on the board of directors. And of those 5 shareholders and directors, 3 of them are also officers, okay? What that means is that you now have overlap between shareholders, directors, and officers. And it's legal, you can absolutely do this, but it can create some really sticky situations that under the law are called conflict of interest transactions. Okay, so let's dive in. First of all, let's talk about corporate officers. Corporate officers are presidents, secretaries, treasurers, maybe they're vice presidents. These are the people who handle the day-to-day operations and running of a business, okay? Now, they have to get paid for that, right? That's a lot of work. And oftentimes, corporate officers can be paid a pretty fair amount of money, especially if the corporation is profitable. Well, who decides how much to pay them? Who decides what their benefits are? Do they get stock options? Do they get a company car? You know, all those kinds of decisions. Who makes those decisions? Well, the board of directors makes those decisions. Well, you might say, wait a minute, didn't you just say that the same people who are officers are also directors? Yes, I did. So if you have a situation where the people who are receiving the paycheck are the same people as the people who are deciding how big that paycheck should be, that is a conflict of interest transaction because it is very challenging as a director to fulfill your fiduciary duties to the corporation, your duty of loyalty to put the corporation's interest first, and your duty of care to make sure that you're making decisions based on evidence and rationality and best judgment, business judgment. You have to make your decisions based on that. And if you're the person receiving the paycheck and you're also the person on the board of directors who is voting on how big that paycheck is, then you have a conflict of interest. Under Virginia law, there are a number of safe harbors that will allow you to avoid liability for that conflict of interest transaction. One of those safe harbors is if the shareholders approve of the decision made by the board of directors to issue paychecks at a certain level. So the shareholders can hold a vote and basically ratify the decision of the board of directors to pay the officers X amount, whatever it is they're being paid, okay? However, if the shareholders and the directors and the officers are all the same people, then you don't have anybody in that stream of decision making who is disinterested, meaning that there's nobody in the course of making that decision who doesn't have a dog in that fight, right? That can leave you vulnerable to a lawsuit from a shareholder who may object to the level of compensation that officers receive. Those kinds of lawsuits can be extremely expensive, and they can actually result potentially in the dissolution of the corporation. So it's very important to understand what conflict of interest transactions are. If you are serving in a corporate governance role, if you are a shareholder, a director, or an officer, and certainly if you are all three or even two of those three, then you absolutely need to have legal counsel as you make decisions, particularly about things that you personally have an individual interest in. If you don't have legal counsel to help you walk through this minefield, you may accidentally leave yourself open to a lawsuit that could cost you a small fortune. Now, that doesn't mean that you've necessarily done anything wrong. It doesn't mean that you're overpaying yourself. It simply means that under the law, there is a conflict of interest, and that conflict of interest needs to be carefully navigated with legal advice. I'm Tricia Dunlap, managing partner of Dunlap Law, a small business law firm in Richmond, Virginia. We love helping business owners understand all these ins and outs and all the nuances of corporate governance so that you can make sound business judgments every day. If this video has been helpful, I hope you'll like, subscribe, and share. If you'd like some advice on corporate governance issues, please get in touch. Thanks very much.